Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Yesterday, August 26, 2025, 3 new documents popped up on the court docket of Idaho versus Kohberger. This is a closed case. It was deemed closed over a month ago on July 23rd, 2025, after Mr. Kohberger's sentencing proceeding. However, there remains the issue of what appears to be potentially thousands of pieces of paper that were filed under seal during the more than 2.5 years that this case was proceeding. Judge Hippler, back on August 4th, 2025, this is the better part of 2 weeks after the case was closed, rendered an order asking the parties to, within 14 days, provide either objections or non-objections to 2.5 months of the more than 2.5 years of documents that still remain sealed from public disclosure in the closed case. The parties both went right up to the deadline. They submitted their responses on the 18th of August. Those responses are available for you to read on the docket. Another week went by, and now we see the court's order directed toward those 2 responses. And it reads as follows. Order regarding requested redactions. Before the court are the parties' respective responses to the order regarding sealed documents. August 4th, 2025. Both parties object to the unsealing of the names and contact information of the potential lay witnesses and expert witnesses identified in this case. They contend that some witnesses whose identities have been publicly revealed have been subjected to harassment and other concerning behaviors by the public and media. Although defendant has now pled guilty and been sentenced for the crimes, the parties note that the case remains subject to intense media scrutiny. Consequently, the parties anticipate that revealing the identities of the witnesses will constitute an unwarranted invasion of personal privacy as provided by, and the legal authority, the statute and rule of court are given here, ladies and gentlemen, and should be redacted pursuant to rule of court is provided here. Next paragraph. To best balance these articulated concerns against the public's interest in access to information, the court requests additional information with regard to each witness whose name and identifying information the parties would like redacted. First bulleted item. The witness's role in the case. Second bulleted item, whether the witness's name is already publicly known, e.g., by known media exposure or the release of other records such as police reports, and third bulleted item, whether the witness has been subjected to threats or harassment, and if so, the nature. Final paragraph, page 2, following submissions of this material, which is to be filed under seal, the court will review the information and either issue a written order or set the matter for a hearing. Responses should be filed within 14 days. It is so ordered. Dated this 26th day of August, 2025, Stephen Hippler, District Judge. Ladies and gentlemen, I would like to add a few comments here if I could. This case, Idaho versus Kohberger, proceeded for more than 2.5 years. And during that time, the state and the defense filed a multitude of documents seeking to seal all manner of information, not just information related to lay and expert witnesses, but information having to do with jury instructions by way of example. Jury instructions are used in every criminal case across the country. Many of them are typically standard, such as instructing the jury on what the burden of proof is in a criminal case, which is beyond a reasonable doubt, or what the judge's role is versus the jury's role. Judge Hippler's order that governed the filing of pretrial matters contained a listing of items that related to the trial that never happened in this case. The jury trial was canceled back on July 2nd, 2025, almost 2 months ago, after the parties entered into plea negotiations that led to the change of plea hearing on July 2nd, 2025. One of the items, the jury instructions, was never required to be filed under seal, yet both sides asked the court to file all jury instructions under seal in the case, and the court entered an order sealing all jury instructions in the case. I have raised my concerns, as I do under the First Amendment, of the super secrecy of this case, as if it were a matter of national security. That, in my opinion, is what this case felt like, rather than a case dealing very tragically with the unaliving of 4 students, but it is a difficult and a hard fact that unalivings unfortunately happen every day in this country. As of today, not one single piece of paper that has been under seal and kept from public disclosure has been unsealed by Judge Hippler. Regarding the specific issue of witnesses' names here, the parties are asking, it appears, for witnesses who have come out and have participated in documentaries. They've given their names. They've given their statements of what happened on that tragic day. Are those names people that the state or the defense want to continue to be not disclosed to the public, although they've come out and voluntarily given statements without the benefit of ever being cross-examined on the stand? That's what trials do. They give the public the opportunity to see lay and expert witnesses on the stand, not just examined by their proponents, the people who are offering them, but cross-examined by the other side. And that's where the truth a lot of times comes out when you watch the body language of the witness on the stand, how they react to questions, any inconsistencies that they may have given. All of this is not going to happen because the trial was canceled after Mr. Kohberger entered his plea of guilty. So it continues to be a complete mystery why even the records that the parties have no objections to being unsealed still have not been unsealed in this case. I give my opinion per the First Amendment, and I ask for your opinions, your comments, your feedback, your thoughts regarding this matter. Until next time, this is Kathy. Thank you for joining us here today.